Pavilion Banqueting Hall, comprising 2 beautifully decorated modern guest suites with seating capacity for up to 1,100 guests. An ideal choice for engagements, weddings, Mendi parties, exhibitions and seminars. Supported by the latest sound and video technology, air-conditioned and free Wi-Fi. Contact us today and see how we can make your vision a reality. The Eastern Pavilion Banqueting Hall, located on Featherstall Road South, Oldham. A perfect choice for your perfect day.
The contents of this program may not necessarily represent the views of UK24.
The Eastern Pavilion Banqueting Hall, comprising 2 beautifully decorated modern guest suites with seating capacity for up to 1,100 guests. An ideal choice for engagements, weddings, Mendi parties, exhibitions and seminars. Supported by the latest sound and video technology, air-conditioned and free Wi-Fi. Contact us today and see how we can make your vision a reality. The Eastern Pavilion Banqueting Hall, located on Featherstall Road South, Oldham. A perfect choice for your perfect day.
Assalamualaikum and welcome to Know Your Rights, a new program which looks at the legal matters that affect you, and in particular immigration law and family law is something that we're going to be concentrating on. And before I say anything else, I want to invite our expert who's going to be helping us to ensure that we get the information across, is Barrister Shazia Anjum.
Thank you so much for Walaikum Salam. Thank you so much for inviting me here.
Thank you. I mean, Shazia, obviously you're a barrister and you've been practicing since about 2002. Originally you're from Faisalabad, but you've obviously done the relevant qualifications, and alhamdulillah you are a very successful barrister within your own particular field of immigration law and family law. Today is something that we want to start with, is to look at the topic for today. We're going to be looking at immigration law, and in particular one of the things that we want to focus upon is post-Brexit, the issues are affecting us, and those people that want to invite their families over. What are the rules? What are the requirements? And the very technical things that people want to know more about. So, can you just tell us, generally speaking, the kind of clients that come to you when it comes to these 2 particular fields? And I think if, with your permission, I want to start to look at the British children who are here, and if one of their parents is abroad, whichever country, and they're applying through the immigration system, what sort of things should they be thinking about? And can we start with that?
Thank you very much, Shanaz. This is quite a hot topic for immigrants because some of the immigrants cannot meet the requirement of spouse visa. Because when we talk about spouse visa, then we have to meet the financial requirement, which is quite high for some people. We also have to consider the English language requirement. But some people cannot meet these requirements.
What is the income criteria at the moment? And because one of the things that people are very confused about is there is one income for the individual, and then if they've got any dependents, there is an additional, isn't there? So
that's right.
What is the requirement at the moment?
The basic requirement, the financial requirement, is £18,600
Okay.
for your spouse.
Okay.
But if you have dependents, then for each dependent, for the first dependent, there will be 3,700, and afterwards, for every dependent, you have to show £2,400.
Gosh, that's a lot of money, isn't it?
And some people cannot meet these requirements, and then it means that they think it's impossible to come to the UK as a parent of British children. But the purpose of this program is to give awareness to those people who cannot meet the financial income threshold, but they want to come over here in this country because they have British children born.
So, Barrister Shazia, let's get this clear. For this is for those people, a parent of a child who was born here, right?
Who are British.
Who are British.
Whether they are born in this country or in another country, but they are British children.
Okay. Give me an example, because
for example, father is British, and father goes to the other country, let's say in Pakistan or in India, and they get married there. In the meantime, they cannot call their wife over here. In the meantime, their British children are born. The children are born in Pakistan or India or in the third country. If their father is British, then
or their
will
mother,
be
or their mother is British,
or their mother is British. No, I wouldn't say that, because then different rule applies.
Okay.
Let's say for father.
Okay.
Father is British, and the child is born in another country.
Okay.
Then they will be British by birth.
Okay.
They can acquire their British passport through British embassy in that country, and then this is where we are going to inform people which kind of category, category of visa they can apply for.
Okay, so let's start with the first scenario, being the father is British. Okay, so the father is British and the child is born, he's gone to Pakistan or Bangladesh, he's got married and the child is born, but the mother hasn't come, so obviously the child is born in that country.
Here they have got two choices. One choice is either to apply as a spouse of British person, and the other option is for them to apply as a mother of British child. So our program is about the mother of British child who does not need to show the financial threshold and who does not need to show minimum English language requirement.
Okay, so there are certain exemptions then. Are you talking about exemptions of those people who are a British national and they have a child? So, I mean, I wasn't aware of this. My assumption was that they have to meet the financial criteria no matter what. So
this is for spouse requirement.
Okay.
If somebody wants to apply as a spouse, then they must meet the English language requirement, they must meet the financial requirement as well, which is £18,600. But if their child is British, then they are exempted from these requirements, even if some people say our wife is not, is not literate enough or has not got any knowledge of English and cannot meet the English language requirement. This is where they can be exempted, but then we have to assess their eligibility, for example, whether or not they are eligible in terms of the British child.
Okay, I mean, this is something I'm sure the viewers out there, for those people that are not, I mean, I wasn't aware that there were certain exemptions in terms of financial exemptions. I know that there are certain other exemptions that come in. So where can people get this information from? Because if they have a child that is born outside the UK and that child...
First of all, they need to make sure that the child is British. They can get information either from the British Embassy, they can get the assistance from any lawyer or who is a specialist in immigration area, and they can submit an application to get a British passport from that country. Once they get the British passport from the British Embassy, then the next step is then they can apply as a primary carer of British child.
Now, that application, Barrister Shazia, does it need to be made from the UK by, say, the father in this example that we're giving, while the mother is there in Pakistan, or does it need to be made on behalf of the mother? Who makes the application and how is it made?
Here, the sponsor is going to be father.
Okay.
Father is
the
going
British
to be
national.
the British person, and the applicant will be mother. Mother will be applicant, but in terms of submitting application can be submitted either from the UK or from the other country, Asian country. So they can submit application from any country, because now this is the portal system. So whatever documents are needed, you can just email the documents to the solicitor or a legal representative, and then they will submit the application on behalf of the applicant.
Okay, so everything's done on a portal, it's all submitted online.
Yes.
Okay, so what sort of things do people need to be thinking about? If they have a child that's born outside the UK, they are a British national, and they want to put in the application, is there any age limit or how many children?
This is very important, because the test here for them to prove that they are primary carer of British children.
Okay.
Either this is one child or it could be more children. So as long as the applicant shows that he is the primary carer of the British child, then it means that the test, the requirement of this kind of category is met.
How do you show that? How do you prove that you are the primary carer? Because Zahra, they might be sending money over or supporting, however, but there's a whole family structure, isn't there?
As a mother, the applicant needs to show that she makes the decision, day-to-day decision for the child. She is the main person to upbringing for the child, and she needs to show that she, for example, if she's taking care of her or his health, child's education, child's future decisions. So this is the things we need to establish by the evidence. So we need to collect the evidence from the applicant, and the applicant needs to show these tests and the evidence in order to meet the criteria of this application.
Now, it sounds very simple, doesn't it? But it's actually a bit more than that, isn't it, in terms of the evidence that's required. So the person who's here, who is the father or the mother, let's talk about the father, because I think you said that with mother it's slightly different. So if the father is the British national, they have children or a child in, within Pakistan or wherever, and they want them to come here, and they are the primary carer. What sort of evidence do they need to collate? Because we don't collate evidence, do we? Normally, we don't keep evidence of day-to-day interaction.
For example, when the child is born in hospital, they can collect the evidence from a doctor. They can get the letter from hospital, and then if the child is going to school, they can collect the evidence from school as well, from teachers, to show who's going to pick up the child and who's going to drop the child to school. So these kind of evidence.
But that will be there though, Barrister Shazia, won't it? That will be the parent who's resident there. But the parent who's here, how do they show their connection?
Their connection will be shown by the marriage certificate.
Okay.
Because they only need to show that they are and the birth certificate of the child. They need to show that they are married together and they have the child together. So the threshold is to show the relationship for them together. But in relation to the children primary carer test, it's the applicant who needs to collect the evidence from their home country.
Okay, so the applicant here will collect the evidence, say, from their wife, who's the carer.
Now, the applicant who's, let's suppose we give example, the applicant is in Pakistan, they need to collect the evidence from Pakistan, from the different institutions, and they will provide their own evidence to the solicitor.
Okay, okay. And their solicitor, are they going to be in that country, or can...
The legal representative could be from any country, but most people prefer to hire a solicitor from England. The reason is that, for example, if they are coming to the UK, then the solicitor or barrister or legal representative from this country may be, more aware of the regulations, rules, case law on daily basis, because they go to courts, they face Home Office, so they might be, more appropriate people to represent them.
I mean, anybody that does have a child who's watching this program and maybe a second marriage or a first-time marriage or more, you know, in terms of what should they be saying to their partner there in that country? What sort of, you talked about letters and things, what should they be saying, that things that they need to be aware of? Because obviously they're going to collate this evidence over a period of time.
It's a very important question, because mostly what people do not keep any evidence, right? And this is where, their application can fail. When you do not collect your evidence, when you do not get the documents from the institutions, then a solicitor cannot do anything about it.
No.
So it's the applicant's duty, responsibility to keep the record, get the evidence from the institutions. As I said, if you need the evidence from schools.
What sort of things? Because I'm thinking that...
From counselor, from hospitals. And every person has got the different circumstances and backgrounds. So if people are not sure about what kind of evidence will be applicable onto their particular circumstances, then they can speak to their representative. They can get further details of the documents, what kind of documents will be suitable in their circumstances. So they will be more, precise about the circumstances, what kind of evidence will be.
Because the reality is, Barrister Shazia, is that people obviously are looking after children. They're going to be on their own. The primary carers, they've got everything to worry about that two parents normally worry about. They've got one parent there who's living with the children, and time passes by, doesn't it? So this kind of worry is there. But can you give an example of from a school, what kind of letters will be collated? What sort of things should they be starting to get together?
The school needs to mention the name of the applicant on the letter, for example. If that, there should be correlation with the teacher and the parents who are in that country. They need to just mention in that letter what kind of responsibility they have evidenced that the mother was taking over for that child. If mother was going there to meet the teacher, discussing the progress of the child's education, or if she's going there to drop the child, to pick up the child from the school. So whatever circumstances are there, it needs to be mentioned in the letter.
Does it also need to be mentioned, the parent who's absent because they're here, does it also needs to be mentioned of any interaction between the school and the child and the other parent? Does that need to be mentioned as well?
The person who's living here, if they do not have any direct connection from this to the school, then obviously they are not going to write it down. They will only write it down whatever they have evidenced with the applicant.
Is it important?
Most important is the evidence in relation to the applicant, not in relation to the sponsor. Okay. But for sponsor, it's more important to show the relationship that sponsor has, the relationship with the mother and with the applicant.
With the child. You mentioned school, you mentioned obviously the hospital. Anything else that they need to be sort of collating? Because I'm just thinking that you as a barrister will be saying, give me this, give me this, give me this, and they're thinking, no one ever told me I need to keep this. People don't keep documentation. And from my own experience, I found that I ask people...
It could be letters from MPs, letters from councillor, the social letters, whatever the social NGOs are there, if they have any connections with them, they can just give evidence that they have evidenced for this child, that the applicant is taking care of this child on a daily basis.
Okay, well, we're going to go to a quick commercial break and we'll continue our conversation. I've learned in terms of what can be done. If you have got any questions, and I think there is a question now that we'll deal with straight after the break, please do send your questions through. And we're going to use this programme through the comments section for people to put in their questions and any queries they've got on this particular topic. So let's go to a commercial break. Straight after the break, inshallah, we'll start to have a look at some of the questions that have come through. Thank you.
The Eastern Pavilion Banqueting Hall, comprising 2 beautifully decorated modern guest suites with seating capacity for up to 1,100 guests. An ideal choice for engagements, weddings, Mendi parties, exhibitions and seminars. Supported by the latest sound and video technology, air-conditioned and free Wi-Fi. Contact us today and see how we can make your vision a reality. The Eastern Pavilion Banqueting Hall, located on Featherstall Road South, Oldham. A perfect choice for your perfect day.
Welcome back to know Your Rights. Now, we've been talking about immigration-related issue for somebody who lives in this country who may have children in another country and wants to invite them over. So they're the spouse and they have the applicant is in that particular country, let's say Pakistan, and have children. We've got a question here. What if the person is not British now and he has children in Pakistan? Can they obtain their British nationality first?
No, they can't. There are set rules. If the person is British and their child is born in Pakistan, then he or she will be able to get the British nationality from there. But if the person is not British, the person's child is born in Pakistan, then there will be other routes to come here in this country as a dependent of that person, and then the totally completely different criteria will be applicable.
Okay, so they wouldn't be able to go for the British nationality, but there still is a route for them to be able to join
their father in this country. There are some routes, but then the financial requirement and English language requirement and the maintenance requirement will be completely different.
Mm-hmm. And it'll be applicable. So the 18,600 that you referred to at the beginning, because communities like to know these figures. So somebody who's not a British, hasn't got a British passport, so may have...
That's quite complicated. The only £18,600 requirement will be applicable onto the British citizen.
Okay.
If they are not British, for example, as you've just mentioned, that the people who are in this country are not British, but they have their children born in Pakistan or in other countries, then it means that there will be separate requirement, not even 18,600. For example, I will give you example like refugee status. If they want to reunite or unite their family as a family reunion in this country, they do not have to show £18,600. They only need to show the maintenance requirement in this country, and that will be the different set of rules that will be applicable, and then the income threshold will be the different as well. It depends how many family members will be coming over here, and they need to show the maintenance, how they will be able to maintain them. Likewise, if people are here, for example, in business visas, people are here in other category as a European national, then the financial requirement will be completely different.
Okay, so let's look at the example of, for example, somebody who's European, somebody that may have come from Spain or Italy and is settled here at the moment. We haven't actually gone through Brexit yet. So what will be the situation for a European national? So they're living in this country and they have children back in, say, Pakistan.
Yes.
And they want to invite them. What category will they fall under?
In this category, they won't need to show any financial threshold requirement. They can join their father in this country, and they don't have to pay any fees.
Okay, so how...
They don't have to show any financial requirement as long as that European national is working in this country and he's earning even little money part-time basis, full-time basis, he's earning £1,000 a month, or he's earning £800 a month. If he can show that he's qualified person, the European national is working in this country, and he's a qualified person, then this is sufficient for them to call over their family.
What do you mean qualified person? So
qualified means that whoever is working. For example, if European national is living in this country and he is not working, he is not qualified person, then he cannot call their family over.
Okay, but you're saying there's no income threshold for
No,
them?
18,600 is not applicable onto the European national. So as long as they are working in this country, even if on part-time basis, they can call over their family.
Okay, now I've got another question here. What if they have indefinite visa? So somebody has an indefinite visa to leave to remain here, so they've gone through that process, but they don't have the British nationality. Can they?
If their child is born in Pakistan, they won't be able to get the British nationality.
But they can apply.
But if the child is born in this country, then the child will be able to get the British nationality.
Okay, so I've got another question coming through, but for now, for somebody who's got indefinite leave to remain here, a child that is born here, they will get their British nationality because that's born by nationality by right, isn't it? Because they were born here.
Yes.
But if they have a child abroad in another country, they can't get their nationality, but as you said, because they're parent here,
then they can apply as a dependent
of that
person, and then £18,600 will be applicable.
Is applicable. Yeah. Okay. Sorry, I think I've got another question coming through. Somebody, we've got. I'm just trying to listen to the. So there was another question that came through. So we've got somebody that's born in Holland, and her father is from Pakistan, but she's British because her mother was British, so there's a difference here.
Okay, the mother is British, child is born in Europe.
I'm just going to say, if the technical team can send that question through to the comment section, because it's very difficult.
No, let me just explain, because...
What's the difference, Barrister Shazia, between the mother and the father?
If the child is born in a European state,
yes,
then this rule will not be applicable onto them. This is different. This is special for Commonwealth countries. You know, the options we have been discussing before, this is just only for Commonwealth countries, and for example, Pakistan, Bangladesh, India, all the Commonwealth countries can benefit from that rules that we've just discussed before. But if the child is born in European state, they won't be able to get that benefit. It means...
What about the rule when often filling up the 1986 rule? So if you're born before 86 or after 86, where does that come in? Because often, you know, in the application, that is one of the questions that comes in, and people think, oh, what does that mean? What relevance does that have in the application? What rules there?
I mean, there were some rules before when totally completely different, but now the rules have been changed, because when people were born before that 1981, and then they were able to get the British nationality. But then after that period of time, when the children are born in the other countries, then it means if the mother is British and the child is born in Europe country, let's say, then he wouldn't be able to get the British nationality. Even though the mother is British, but then the child wouldn't be able to get the British nationality because the European country, do not come under the Commonwealth countries. So then the different rule will be applicable.
What's the difference between the sponsor being a father or a mother? What does the rule change? In terms of the application? So for example, if the mother is here and she may have children from a former marriage or whatever, and she's come here. I came across a case a few months ago where the mother got married, came here, so then she became British, yes, and then she went back. Unfortunately, she got divorced. Okay. Then she went back to Pakistan and she got remarried and had a child there. How does the rule change there then with circumstances like that? It's a bit complicated, but so she's already British and she's got married again, and her children, she's got some children from her second marriage in Pakistan. How does that rule change with her being the main, and the sponsor
There are different routes. For example, if mother is British and the child is born in Pakistan, the child may not be able to get the British nationality. If the father is British,
yeah, sorry, go on. Sorry.
yes. So if the father is British,
so the father is British.
Yes.
She's British. She's got the child is in that country, so she's gone over. She's had the child there. Then can the child just come and travel straight away, or what do they need?
It's very simple. They will. The child will get the British passport from the embassy, and then the child will be able to travel to this country.
Okay, I've just got a question that came through my ear. There's something that's been sent through. This issue of dual nationality. A child that is born in that particular country, and if one of the parents is here, then do they have a dual nationality straight away? They're Pakistani nationality and British later on. How does that?
And who is Pakistani, a father or mother?
Father.
Father is Pakistani national,
yes.
And mother is British national. The child is eligible to get the dual nationality then.
Okay, and what if it's the mother?
What's the exact question from the audience?
Yeah, they've asked both. They said if the father, in this particular case, it's actually a Bangladeshi father, and his wife is British. So they wanted to know if the child is born in Bangladesh, then what nationality do they have? Do they have? Obviously, they're going to apply for the British nationality, but do they still have a Bangladeshi
the child
nationality?
will get the nationality through father.
Okay. Through the father.
If the child is born in Bangladesh, then the child will get the nationality through father.
Okay, through father. Is it quite complicated? Because
it's not that straightforward, even though it looks like it's a simple, but then every case has got the different set of scenario, and every case has got the different circumstances. So the solicitor or the legal representative will have to assess the case fact by fact, and then they can only give the particular advice once they get the information, background information. So what's the background of the parents, what's the background of the father, what's the background of the mother, and what are the circumstances, other sibling, for example, if it's one marriage or any ex-marriages. So many, things to consider when we have to give particular advice to a client.
Obviously financial information is one thing that people are always concerned about. The other one, I think, has become English language. And we've got a question here on English language. The question is, if there is there any alternative if someone is unable to pass their English test? Is there any alternative?
Only alternative will be for British child's parent. So if someone has got a British child and that person, the applicant, is the primary carer of the child, then they can get the exemption from the English language requirement, and it may change in future as well. Let me just tell you, because it's a bit complicated. There are mixture of immigration rules and the European regulations, so that's where they are getting exemptions from. But if after Brexit, then the situation may be different.
Do you think it's going to be any better?
You never know.
A question of fees has come up, but I just want to just ponder on this scenario. So there is, the father is here, and he has an indefinite leave to remain. The mother is in Pakistan, and they have a child there as well. But the mother is not able to pass the test. She's totally illiterate. She's tried, she's failed.
Unfortunately, then she has to pass the English language.
But if the father has a British passport, if he is British, then...
And the child is British.
And the child becomes British because of the father.
Through the father. Status. And then she will be able to get exemption from the English language.
So I think the answer to this particular question then is that this father needs to get his British passport first. And then the child will become British through father.
No? There will be different requirement, because even if the father gets the British passport, still the child will not be British by descendant.
They'd have to put it in application, wouldn't they?
They will have to be, there will have to be application as a dependent, and there will be financial requirement needs to be met.
Is that because they were born after the person became British?
Before the person became.
Before the
Yes.
sorry before
Yes.
before
Yes.
so so the child was born after, so it's actually the status of the sponsor at the time of birth.
At the time of the birth.
Ah, right, okay, so it's at the time of birth. So it's very interesting. So lots of questions are coming through, which is very good. Now, in terms of say somebody has some kind of disability.
That's a very good question, actually. That's a very good question. So if somebody has got the disability, then they want to call their spouse over and they do not have any British children, then still they can get the exemption from financial requirement.
Okay, so the person here is the person with a disability.
And he is receiving the disability allowances.
And does it matter which category he falls into, the type of disability, or?
Yes, it does matter. It does matter. On weekly basis, they have to show that they are claiming, I think it's making...
There's a lower level and a higher level.
100 and plus something amount they have to claim. It's not like lower level. If they're claiming lower level, they might not be able to get the exemption.
Okay.
And then their application will fail. But then if they are just getting the higher level of disability allowances, then they will be exempted. They can get the visa status in this country without showing the financial exemption.
And that is for their spouse and their child? Or would it matter?
I mean, in these situations, we are talking about when they have the dependent in their own country, so both dependent can get the status.
Okay, so that's... And what if, on the same scenario, what if the spouse, or you're referring, the applicant in that home country, what if they have some kind of disability?
It doesn't matter. They won't be able to get the exemption.
No.
Because it has to be British person who is facing the disability and he is receiving the disability allowances. The spouse will be, the applicant will be able to get the financial exemptions and to come to this country. They don't have to meet that £18,600 requirement then.
Okay, so somebody that has got some sort of special educational needs or some kind of disability, if they go back home when they get married, then the requirements for their spouse, and then if they have children, are those different to somebody? This is a British national, so is this correct? That the person here that has a disability or any kind of special educational needs, because obviously that's in
if that person is British, yes. If he goes to Pakistan, gets married, and in the meantime their child is born, then the spouse and child will be able to come to this country without meeting the financial requirement of whatever. For spouse, £18,600 plus £3,700.
So what is a requirement then? What do they need to prove then? If somebody, so they have no financial...
They need to get the letter from the department, DWP, which proves that what kind of disability allowances they are receiving. They need to prove that. Plus they need to prove the maintenance as well. They can get the third party support. They can show that they are still able to meet the maintenance requirement for the applicant. It does not mean that you do not need to show anything. Still you need to show the maintenance. And maintenance could be from third party, maintenance could be from the higher level of the disability allowances. Or
so it's financial support, financially they need to be
You need to
stable.
show the financial support in any event, but then you will be exempted from the strict requirement of £18,600.
Okay. We've got another question that's come through. We've talked about disabilities, and disabilities in the sense of it could be a physical. But what if the person can't pass the test because they have some sort of mental health problem? Is there any issue? Is there any?
If somebody has got the mental health problem, they can get the letter from the hospital or doctor, certified letter, then they may be exempted from the English language requirement.
Is that? But that's for here, isn't it? But in
no,
terms
it's for the applicant.
As well?
Yes, as well.
So for example, somebody in one of the countries, Pakistan, let's say, for example, or Bangladesh, and they have mental health problems.
They cannot pass the English
and they can't
language.
And they have.
They can get the exemption in this scenario.
Okay. And what sort of evidence will? What is strong evidence, Barrister Shazia? Because one of the things that we hear the word evidence. Well, what is seen as strong evidence? Something that's going to be acceptable.
This is another question whether or not the Home Office accepts the evidence, because the evidence has to be reliable, it has to be credible, It has to be actually obtained by proper resources which can be verifiable, which can be, Home Office can make inquiries about it, and then it should be credible evidence.
Okay, so it's ensuring it's, and are there certain hospitals and certain doctors that fit into that category of where their evidence is more credible than others? Because sometimes that happens, doesn't it? Where it's an institution
as long as it's a registered doctor, MBBS doctor, and working with a hospital, I think that should suffice the requirement of the letter from that credible person.
Okay, now we've got another question that's come through. Somebody travels abroad and they fall into a relationship and it's not a marriage and there is a child that is born, then and they basically father that child. Yeah, can they put in an application to be the sponsor of that child?
As long as they can prove by DNA reports that he is the legitimate father of the child, yes, they can.
They can do. So marriage is not something that is an absolute must in these applications?
No, it depends what kind of application the applicant is making. For example, if the applicant wants to submit their application as a spouse of the British person, they have to show that they
are a spouse.
Are the spouse. But if the applicant is submitting the application in terms of durable relationship, longer relationship under the 2 years private category, they have to show that relationship with the evidence. And if that person wants to apply as a primary carer of the British child, then this is another scenario. They have to show that she is a legitimate mother through DNA test, and then also she's making day-to-day decisions, and she's primary carer of the child.
So they don't have to be married for her
as a primary carer of the child.
A primary carer. So she's basically a partner. But what if the mother? I'm getting lots of questions that are coming through my ear. People are actually sending the information through. Some of them don't want to come online and put the information on, so that's not a problem. A very personal question: what if the mother of the child who is born outside marriage objects to that child coming to this country to join the father?
Well,
lots of healthy fathers out there who are thinking, what do I do now?
Okay.
Maybe you should marry the mother.
Yeah, if we talk about
be an honourable man.
Yes, if we talk about the rules or regulations, what law says, then as long as that person meets the requirement of being a legitimate mother of the British child, even if the sponsor in this country objects, it shouldn't make any difference.
No, what I'm saying is, for example, the father is from here, and he's gone. He's had a relationship, and there's a child born.
And the child is getting the British passport afterwards. This is what you mean.
He wants to put in the application. Does he need the permission of the mother for the application for the British passport, and then also the application for the child then to join the father? They're not together. They've had a child together, but they're not together. Do you understand? What if the mother objects? The natural mother objects.
If they want to, if the couple wants to apply for a British passport, yes, both parents needs to consent. For British passport to get the British passport.
And if the mother doesn't consent, but the father wants to?
This is another question. This is not the application by the applicant to this country. This does not, address that issue.
Yes.
But this is in relation to the British passport application for the child itself.
Yes.
Then if any of the parents objects, then they can get the court order.
Okay.
To get the British passport.
So, for example, the father here.
There are other procedures to get.
Yeah, there are other procedures. So, we're just trying to look at all the scenarios.
But if they do not get the court order, then it would not be possible to get the British passport for that child.
Okay. Some people have asked for your details, and we can pass those details on for anybody that does contact us, because we don't want to, at this moment in time, do that. But Barrister Shazia,
because this is where international international child abduction takes place.
Yes.
For example, if one of the parents is not ready, and the other parents want to bring over or takes over the child to the other country, then this is called international child abductions, if one of the parents objects to that. But if they get the court order and court is satisfied that this is in the best interest of the child, then they can get the passport, they can bring over, they can take over.
So there's a legal procedure that they have to follow in order to meet the requirements that even if one of the parents does not consent, then the actual law actually says, correct me if I'm wrong, that it is the child that is the essence, the important aspect
then
of this.
The court will look into the, background, different circumstances, whether or not this is in the best interest of the child, which country he or she needs to live in.
Okay. Finally, obviously we're going towards Brexit, and next week we'll concentrate more about what Brexit will mean in terms of immigration law. This was something that we were going to look at, but lots of things have come in. Does it matter whether it's at this moment in time, before we actually Brexit, that which country, UK and European countries, does it matter, for example, a country like Pakistan or Bangladesh, a Commonwealth country, is there a big difference between which country you're from?
For the applicant?
Yes.
Which application you're talking about?
So, for example, a child application. So we've just been concentrating on British child of a parent, right? So a potential British child, or a child that is born to a British national.
As long as this comes under the Commonwealth countries, so there's no difference.
No difference. So at the moment there's no difference.
Yes.
So as long as it's a Commonwealth country and it's with UK and European law. Obviously we don't know what's going to happen in the next few weeks to come. Do you see a lot of changes?
All the changes will take place after June 2020. In the meantime, there will be some interim plans where people can benefit from, because it's not going to be sudden change, dramatic change. There will be slow change in the immigration process, even if this is European national applications, their family members or extended family members application. It's going to be the slow process after Brexit. Even if the Brexit is going to take place on 31st of October, let's say, but still there will be, the applications will continue to take place unless June 2020, and afterwards there will be some changes.
Okay, so there'll be an interim period, so people don't need to worry too much about what changes.
They are, they are getting worried about, because even if it's not going to be dramatic change, but still the slow changes are taking place. So somehow, somewhere, the applications are going to be affected. But this is the interim period. They do not need to be worried about too much. They need to be worried about if they can submit their application as soon as possible. This will be in the best interest of them. But if they do not want to, submit their application, then the worrying, the changing point will be June 2020.
Okay. Generally speaking, there's lots of information there, but generally speaking, is it somebody that has an indefinite leave to remain here? Is it better that they, if they're going to go if they're going to go into marriage or going to go into a relationship with somebody, do they have a stronger position legally if they are British national than if they have indefinite leave to remain, or does that not matter? Generally speaking.
Generally speaking, when they want to get married to somebody, there is no time limit. They can get married anytime. But if you just speak about the more rights of the immigrants, then if the person is British, then it does make a difference.
It makes a difference. So generally speaking, just to understand that if they are thinking,
if they can submit the British citizen application, they can get acquire the British citizen nationality, for example, British nationality, then this will give them more chances to be successful.
I'm just trying to think of all those people that have never put in an application for a British passport because they think, what's the point? And because it's very expensive, the application, I'm not sure what it is for a British passport at the moment, but I remember when it was free. People didn't do it then, and then the requirements came in, the English language, and it's becoming harder and harder.
As compared to getting or acquiring the British citizenship status, I wouldn't say it's very expensive. As long as you can meet the criteria, you have the good character history for the last 10 years, and you have no criminal record or civil conviction, civil judgment against your name, then this is the better opportunity or better chance to apply for British citizenship.
Well, thank you very much, Barrister Shazia. I think lots of questions have come in and lots of things have come through my ear, and obviously we've had a number of people that have actually been watching and sending their questions. Next week, we're going to actually look at the impact of Brexit and some of the things that people need to be thinking about are some of the changes that will possibly come in. And then in weeks to come, one of the other areas that we want to look at is domestic
violence.
Domestic violence and the things that in terms of people knowing their rights, or from a father's point of view, mother's point of view.
Because not only the women who just get the victim of
domestic
violence. I have seen many cases where men faced the domestic violence as well.
Okay, well, thank you very much, and inshallah we will tune in and watch next week and ask those questions. Now we are going to ask, I think you've actually done it today without me even asking, is do please send in questions and any comments that you've got, in particular questions. Next week we are going to be looking at the impact of Brexit and what that will mean in terms of immigration law, and then we are going to touch upon, if we have time, on domestic violence. If not, then we'll move that on to further weeks. And please do send your suggestions and comments through. And one thing I would like to say, with your permission, Barrister Shazia, is that the advice that we give is very general advice, and obviously from case to case it differs. So please do seek legal advice
before taking any decision.
Please look after yourself, and see you very soon on another show of Knowing Your Rights. Assalamu alaikum.